I'll have to start that all over again because I hadn't turned my microphone on. My apologies. Welcome to everyone out there on the interweb and to ratepayers who have joined us in the chambers. We're reconvening the meeting from the 18th of December and we're restarting on page 507 of our agenda. Currently, we're working through a process of looking at the draft district plan, which this subcommittee has been asked to scrutinise on behalf of council. They will make recommendations to council, but it will be the full council that gets to decide whether they approve the draft plan to the point of where it becomes proposed. Then we get into another fairly comprehensive and prescribed process to take the plan through to where it then becomes operative. I'd also like to just explain that there is a planning hierarchy in New Zealand, and whilst all this is happening under the umbrella of the Resource Management Act, we're also guided by national and regional policy statements. So whilst it is the desire of the Waitaki District Council to have a plan that reflects the needs of the Waitaki District, we are also leg roped by directive from central government. I also point out that we also have other councillors who aren't on the subcommittee joining us around the table today, and we thank them for their participation and interest. They are totally welcome to make comment on issues as they arise. However, they will be excluded from the voting process. So without further ado, Councillor Hopkins, I'm going to ask our planning manager, David Campbell, to open the meeting, but Councillor Hopkins, you have a question.
Well, I did, yes. I just wondered, Mr. Chair, if you'd be willing to allow some reconsideration of chapters previously revisited on the basis that some of us may have new information or wish to ask questions about matters that haven't been canvassed previously.
I am comfortable with that. But we'll take those as they arise. So, Madam Chair.
Excuse me, through you, Mr. Chair, I would just like to make some apologies for this particular meeting, and that is for Councillor Blackler for this morning's session, and an apology for lateness for Councillor Percival, who is on his way. And there'll be an apology for the afternoon session for Mayor Kircher.
I know those apologies be received, accepted.
Thank you, Councillor Hopkins, and thank you, Councillor Linwood, for seconding that. All those in favour, please say aye.
Okay, and if I may then proceed to the next item, agenda item on declarations of interest. Councillor Blackler will be making a declaration in this afternoon's session, just to let you know that, and I will be recording it as part of the declarations of interest agenda item in the minutes.
Thank you very much.
Thank you, Mr. Chair.
All right, David, you're in the starting gates.
Thank you, Councillor Thompson. Just before we get underway with where we left off last time, I just note that in the agenda, which is coming up in terms of the schedules, attachment 30, schedule 8 is a double up of the one above it, and there will be a schedule 8 called outstanding natural features, which wasn't available for the agenda there. So there's been some working of that, and that also means that when we look at the maps for the outstanding natural features, there won't be any corresponding schedule to refer to. So it's probably best we defer that to the 18th of March, just so it can be considered properly. The schedule below that, the significant natural features can be considered. It doesn't have the numbers for each feature, but we can update the numbers also on the 18th. So you've got a correct numbered reference to each one. You can still refer to them and discuss them today, but just a heads up that there's a slight change there we'll need to do to cover that off in the next session, unfortunately.
Can I just stop you a minute?
Just to clarify that for everybody in the room and who's watching, so there is a new schedule, attachment 30, schedule 8, which will be called Outstanding Natural Features, that will be published, and the meeting will be reconvened on the 18th of March in order to discuss that. So it will be published ahead of that meeting. Thank you.
Thank you. I guess where we left off and coming up with the SNAs and landscapes schedules, and then that flows into the maps that are also part of the agenda. There's a lot to work through there. There's been a lot of discussion and dialogue with landowners on these matters, and Max is happy to sort of give a bit of a summary overview of some of those before we sort of dive into it. That's helpful.
Thank you, David. So we left off talking about the significant natural areas schedule. And so a lot of these areas were surveyed beginning as early as 2013. And while we have more recently peer reviewed all these sites against the National Policy Statement for Indigenous Biodiversity, and all of the sites that are listed in the schedule were found to meet those significance criteria in that new policy statement. Even if that policy statement were to disappear overnight, these areas would still meet the significance threshold under the regional policy statement. So that's just some clarification around where these sit in terms of those policy statement documents.
Well, Mr. Chair, I wonder, at the conclusion of the last meeting, I had moved that a particular SNA number 32 on page 506, that being the Table Hill one, where this justification was that the plant community at the site is moderately representative of the likely original vegetation. I had moved that be removed from the list, and that matter was agreed would lie on the table. So I rather think the first thing we should do this morning is vote on that.
You're right. We did agree to leave it laying on the table. You had moved it, but you didn't have a seconder for that motion. So we will revisit that, Councillor Hopkins, yes. Mr. Campbell.
Yeah, thank you. And just to sort of round off, when we worked through the update of the National Policy Statement on Indigenous Biodiversity some time ago when it came out, it requires us to identify and map all SNAs in the district. And it also has a provision to seek assistance from our regional council, so ECAN and Otago Regional Council. And there has been discussion with them about helping all districts in their respective regions with that work. And we have sort of a 5-year window to do that work, regardless of the plan. So what we've got is a subset of SNAs that, as Max said, have been through, because they were done before the NPS-IB, they've had a peer review to make sure they still fit the criteria and are still relevant. They're the first ones that were done with landowner agreement, and there will still be more needed to be done in the next 5 years to complete the list and meet the NPS-IB requirements, with or without assistance from the regional council. So this is the starting point. The ones we have done, that I guess the easier ones that people are happy for us to work through, and it will still be a moving target as we go through them all over time.
So from that, I would pick up the critical part of that is with landowner agreement. I'm sure that you're aware that all of us are getting contact from ratepayers saying things are happening that we didn't have an opportunity to participate in. How are we going to improve that process?
Under the NPSIB, it doesn't require the same level of sort of detailed mapping to start off with. So we can go and map from known sources or remotely. If it's challenged, then we have the ability to go on site. So it's a different process under the National Policy Statement. The government said they wanted this done with or without landowner agreement, but there are provisions in there how that's worked through where there's disputes. So what we've done is done it the proper way with landowner agreement to start with for all of the SNAs listed. The new process will be different as guided by the National Policy Statement, but still has landowner engagement.
Thank you. We're just hopefully getting Councillor Percival up to today's starting date on page 507 of the agenda. Sorry.
Yeah, just if you use the go-to page, it's the numbering's out on that. So the agenda is numbered 507, but if you use the go-to function, you've just got to put in a higher number.
Something ahead of it, isn't it?
Yeah, this is because of the document that's in front of it.
Yeah, sorry, my apologies. Right, Councillor Hopkins, we're going to go back to your desire to have a particular SNA removed, and I'll invite you to actually expound your argument on that.
Presumably, Mr. Chair, we need a second first.
Yes,
So-
well, rather, I just want you to refresh everyone's memory.
Well, there have been, all right, then, thank you very much for the opportunity. I shall be brief. There was a discussion about the particular SNA on Table Hill, and a number of members of the committee noted that although these areas are described as significant, in this particular context, the plant community on the site is described as only being moderately representative of the likely original vegetation in this part of the ecological district. And though it is modified by the presence and in places the dominance of exotic grasses and herbs, which sounds to me like a perfectly sublime and succinct way to describe something that isn't a significant natural area. And on that basis, and encouraged by the fact, or provoked by the fact that other members of the committee subcommittee had equally drawn attention to the apparent contradiction between the classification and the description, I move that that particular one be deleted. And I move that accordingly again, that SNA 12 on page 506 of the District Plan Review Subcommittee 18 December 2023 agenda be removed from the list of significant natural areas.
Do we have a seconder for that? Thank you, Mayor Kircher. I will then put that to the subcommittee. Those members in favour, please say aye.
Aye.
Those against? Carried. All right, moving on then. I presume it is the desire of the subcommittee that we continue to scroll page by page, and you'll raise any particular issues as we go.
Sorry. Apologies, Mr. Chair. Councillor Percival was asking me a question and I didn't hear what you said.
Oh, I have given the committee the opportunity that we will continue to scroll by page, and you can raise your issues as we get to them. And I've just had a question from Mr. Cook, whether the issue that we've just dealt with is procedurally squeaky clean, that there is no conflict of interest because the landowner in that instance is a council appointed director to a CCO. I'd see that totally removed from this discussion, but is there anyone else have any concerns on that?
Well, if you're asking us to comment individually, I don't.
My comment would be, I didn't realise that. So I certainly made the decision without knowledge of that.
Mr. Cook? Yeah.
Thank you, Mr. Chair. I was also wanted to ask whether whether there was going to be any discussion on that motion before it was put, because we didn't ask for officer comment on the appropriateness of that, given that there's seems to be a lack of scientific evidence to support that decision.
We have had pre-meeting discussions, and Mr. Campbell was forewarned that there are various issues that I believe the subcommittee were going to question. The motion was put and carried. I am happy for Mr. Campbell to make comment after the fact, but it's not going to change the decision. All right, so we move on. I think that the comment in passing is, as Councillor Hopkins highlighted, the description and what was trying to be achieved didn't meet in the middle. And so we've got to be maybe a bit more careful as how we put these things in writing, because at the end of the day, this document is going to be in existence for a long period of time. And whilst round the table we might have an understanding, there will be different people around this table interpreting this document in the future. So we need to be very careful with what we prescribe. Councillor Hopkins?
Yeah, Mr. Chair, you said we could move from page to page.
Yeah.
So, I have a couple of questions relating to classifications on pages 514 and 515, 521. But do you want to go through from 506 and 7 onwards, or?
Yeah, that would be the logical way. So simply, so we dealt with SNA 12, moving on through 15, 16, 17, 18, 19, 20. Well, I thought because I appear to be working off a different numbering than others that I would refer to it in terms of the SNAs, but however, that's probably going to complicate it. Look, Mr. Campbell.
Thanks, Chair. Just a quick comment. The significance justification is a very boiled down summary of the actual SNA report. So the SNA reports will be on the website as part of the plan, so people can link in and see what all of the assessment criteria were. So I'd be just wary of hanging all your hat on the significance justification alone, because it is kind of a summary of what was observed there in terms of vegetation. The report itself covers all the assessment criteria and, as Max said, meets the current NPS-IB assessment criteria. So yes, we could beef out the schedule and add more information in there. That'll be quite large, but what we thought we'd rather do is, when the plan's notified, have all those reports available through a link to the website so people can go in and see a bit more detail. The landowners have a copy of those reports anyway. But if we take your point that the significance justification can read that it's perhaps not as significant as you've mentioned, but that's kind of a summary of what is or isn't there, but not in detail in terms of listing species or anything like that.
Thank you for that explanation. And Mr. Crowe, you wanted to comment on that as well?
Yes, thank you, Mr. Chair. Just to make the comment, to reiterate, yes, those justifications there are a few sentences pulled from much larger reports. In the instance of that site that we've just discussed, a peer review of it has found that it meets each of the 4 significance criteria under the MPSIB. So meeting any one of those criteria would be sufficient for it to meet the threshold to be considered a significant natural area. But in this case, it actually meets all 4 of those criteria. So it's not a marginal case.
Councillor Hopkins?
Well, Mr. Chair, sorry, we voted on the matter. In another report later, we will consider proposals where it is proposed by staff that they can make a staff submission to the notified plan. And in my view, if they wish to on this matter, so be it. But I would be asking them to tell me when they make the submission, did any of the peer reviews take, and I quote from case law, and I quote from case law, any general regard to economic well-being, which is Environment Court case law when considering the sustainable use of land and resources. And the evidence we have had presented to us to date is that no such regard, general or specific, regarding economic well-being has been factored into the process. And for that reason, if there is going to be a staff submission on the matter, I would like to see it more comprehensively in accordance with Section 32 analysis requirements.
Thank you, councillor. My understanding is that when we move into that proposed plan, then that's when the Section 32 analysis has to take place. So I will defend the staff a little in this, that we're still dealing in the draft as against the proposed. But Councillor McCone?
Look, I wasn't going to say anything, but I thoroughly back where Councillor Hopkins is coming from. You know, the cost that some of these people have put up already, I think it should be looked at and you know, once the plan gets notified, then there's more additional cost to what's already going on. I think we've got to scrutinise it as it is, as it sits on this page, and make a decision before it gets to that stage.
All right, well, let's move on, or we'll be here all morning going nowhere. Councillor Hopkins, the next one that you wish to question?
Yeah, look, I've got questions on SNA 27, 28 and 29, all of which relate to Lake Ruataniwha. Now, I rather suspect I'm on a hiding to nowhere here, given the way that the landscape architect sector has managed to co-opt almost everything into the definition of a natural environment or natural landscape or natural feature. But in my view, the 3 words significant natural area cannot logically and rationally include an artificial lake. And SNA 27, 28 and 29 all describe Lake Ruataniwha as an artificial lake, being a large and important area of habitat for Indigenous water birds, etc. And in my view, it may well be all of those things, and it may be a lovely thing to preserve, and it may well be necessary for the protection of Indigenous water birds and the like. It may be necessary to have some protections or conditions around activity and use upon it, but I cannot see logically, rationally, applying the meaning of words in the English language, I cannot see how an artificial lake can be a significant natural area.
Mr. Crowe, would you like to respond?
Thank you, Mr. Chair. Yeah, so through the chair, my comment would be that under those criteria, an area providing significant habitat for Indigenous fauna is a significant natural area, and that break does provide significant habitat for Indigenous fauna, particularly water birds, including several threatened species.
So, under that rationale, then, I need to discourage native birds from landing on my irrigation pond, which hasn't got water in it as yet, but because potentially that's the rationale that we then use.
The key word being significant habitat for Indigenous fauna. So the size of the area and the isolation from other areas and the connectedness with other areas of habitats are all factors that go into that calculation about whether it's significant or not, but primarily because it provides significant habitat for Indigenous fauna.
Thank you. Mayor Kircher?
Yeah, thank you, Mr. Chair. I think we do have to be careful about trying to redefine things, and if they have been defined in law. It's not saying it's an original lake, but it is an area of nature because it's been formed, and I think if we keep trying to use that path, I think we will be on hiding to nothing if it goes to the Environment Court, because they will just not agree with our new definition if they've defined what it is. So probably the question to staff is has it been defined by the courts that an artificial lake is a natural area? Do we have some evidence that that is the case?
Mr. Campbell?
Yeah. All these sites and lakes with landforms have had probably some modification, but they still, as Max said, have enough of a space and habitat for those species. So you could have a more natural lake or estuary. Some of that's probably been modified by drainage or land reclamation. Same with the coastline. So it's really case by case, and if the area itself, regardless of how it's formed, creates that habitat, then it meets the criteria for significance, then it ticks the box for inclusion. So they are all case by case. I guess they are challengeable if people dispute it. But yeah, we're supposed to meet the criteria set out. So it's not just a thing to say, oh yeah, there's some birds on that, so it's significant. It has to be, as Max said, offer habitat of a reasonable scale and usefulness for those species to even go there in the first place.
Thank you for that explanation. Councillor Hopkins, I suggest you lost that one. We'll move on to the next one.
Yeah, okay, thank you, Mr. Chair. I'm rather confidently expected that I would lose that one. The question on SNA 41, 42, 45 and 46. Basically, I'm interested, given that they're identified as being wetland, well, one of them is identified as being a wetland on private land. I'm just curious to know whether these are, 45 is as well. I'm just curious to know if these are actually SNAs that have been included with the owner's consent.
I can help with that one, Matt. Just through the chair, all of the surveys were done with landowner permission, and they were provided the reports at the time. So the ecologist went on site with their permission and had the report and had the ability to, I guess, challenge it or dispute it at that time, but they're listed because they're undisputed.
So just so I understand, you're saying that they are listed because they're undisputed, therefore you've accepted that landowners, by not disputing it, have accepted it.
Yes, so at the time they were done over the last few years, the reports were all provided to each landowner for each one. And, there was discussion, ecologist or staff at that time, if there was any modifications they got made and then a report finalised. So they know that they're there. They've got the report that backs it up and defines the area.
Mayor Cruiser?
Are any of those areas subject to QE2 covenants? Do we know? And if they were, does that change the status or how we view them?
Through the chair, I'm not aware of any of these sites having QE2 covenants over them. And just because the site had those protections that wouldn't detract from their meeting their significance criteria.
Chair, I mean, one of the things we want to do through this is protect environments. If they're being protected already through other mechanisms and we don't have to add a layer of bureaucracy, then why do it? It's a rhetorical question. I'm not expecting you to answer it. I know I do understand why we do it, but actually, from a resourcing point of view, when it's pretty hard to get planners in the first place, trying to increase the workload of council department by increasing areas when actually they're already protected is counterproductive from that perspective. I think we're better off noting that if the QE2 covenant is set up that it will protect the values that we're seeking to protect, then I'd prefer that is a very positive sign that actually that landowner has recognised the values and has done their bit to already protect them.
Thank you for that question. Through the chair, there are, there's many QE2 covenants in the district that have extremely high biodiversity values that haven't been included in this SNA schedule for that reason, that we felt they're already protected pretty well. It wasn't considered reasonable to expend the resources to go and survey those areas if they already have those protections. However, in saying that, a lot of the QE2 sites are not protected just for their biodiversity values. They are protected first and foremost for their open space values. So you can't guarantee that just because an area has a QE2 covenant that it has been managed in a way that conserves the biodiversity values or has been identified for those values in the first instance.
Councillor Hopkins?
Yeah, Mr. Chair, picking up on Mayor Kurtz's point, I'm tempted to test the mood of the meeting as follows. I intend to move, in fact, I do move, having listened to Max and to Gary. I move that any identified SNAs, significant natural areas, in the draft district plan already listed as QE2 as a QE2 covenant, listed in a QE2 covenant, be removed from our schedule.
Before I seek a seconder, Mr. Crowe, can you just reconfirm, you did say that the existing QE2s have not been included in this process?
Well, what I heard Mr. Crowe say, and this is why I moved what I've moved, is that where they knew that there were QE2s, they weren't listed, but it is entirely possible that some of these areas you have duplication. And if that is the case, I'm simply suggesting that the QE2 covenant prevails and the SNA listing is removed.
I'll seek a seconder and then I'll come to you, Mr. Campbell.
I would second that on the provision that we are specific that the QE2 covenant does provide the protection that the overlay would otherwise provide. Because I'm hearing what Mr. Crowe has said, and it is, if we can get rid of some of the overlays, because actually it's the same protections are being provided, then that would be the case. So if the move was prepared, then I'm very happy to second that.
Yes, I'm more than happy. I'm just thinking of this particular set of words we might need. Give me a moment or two and panel beat that in my head.
While you panel beat, Mr. Campbell, would you like to respond?
Yeah, just go back to the kind of starting point with the RMA and in particular the MPS IB. The identification requirement in that doesn't differentiate between QE2 or other types of land covenants or protections. So we don't really have a choice in terms of identifying SNAs or excluding areas for other reasons. So if they meet the criteria, they have to be mapped and included. So the QE2 thing's there as a mechanism to help with like rates relief or other incentives they might get through fencing subsidies with QE2, etc. But the RMA and in particular NPSIB doesn't give us that luxury of saying, oh, it's out because of this other reason in terms of identifying and mapping it.
Thank you.
But we do have the ability to look at the rules, which we've done already in terms of what can or can't happen in near SNAs.
Councillor Hopkins, are you suitably panel beated?
I am indeed. That any identified significant natural areas in the draft district plan that are already covered by a QE2 covenant, which offers equivalent protection for the area, be removed from the schedule.
Oh,
Just clarify with Mr. Campbell that if the motion gets passed, the proposed plan would not be legally compliant.
I guess the issue would be if we pull out any that have QE2, then when we do the complete SNA mapping and survey for the district, they could actually end up back in the schedule because they meet the criteria under the NPSIB, and others might submit to get them included. It would be sort of a unusual process that we take them out, and then by virtue of having to follow the NPSIB and the RMA, that we end up back in through that process.
Mayor Kircher.
No, I know the wise people in Wellington who've probably done, set this up the way they have for very good reasons. But I do ask whether there's potential to have a second schedule that identifies the area so that they are as part of the overall stock take included, but that schedule recognises those areas that are protected already. So we do not, as much as we identify them, we do not apply the rules to those areas because the rules are already, the protections that the rules would provide are actually already in them on that land.
Yeah, I guess the difficulty is depending on the mechanism, various.
Give me your microphone, please.
As I'm aware, Max might want to comment, various QE2 covenants in different conditions. Some allow grazing, some don't, that type of thing. So they wouldn't be exactly all the same. They wouldn't necessarily align with even the resolution that's on the table in terms of the rules as proposed. So the difficulty would be having a schedule that's kind of saying you can have a different set of rules, but we don't even know what those rules are and whether they align or not with the plan rules. So I think we're sort of getting into a bit of murky ground in terms of what it might lead to. By having them as SNAs, it's probably not going to change the way the area under QE2 is managed anyway, because the rules wouldn't generally preclude what they're doing under that.
Can I just, I think there's a sentiment here that's trying to be expressed that we need to acknowledge landowners who have made an effort to protect biodiversity, rather than Big Brother imposing something on them. It's a case of how we can do that in a constructive manner within the plan. That there is no point us passing something here that can't have practical application. Kircher?
I think if we set this up right and send the right messages to the community, they may decide, well, actually, I'd rather have a QE2 covenant there with the protections being very explicit that actually reflect what the rules would otherwise be if it was an SNA. It gives them the ability to have a choice at least in that. And if we can say, yep, that they have reflected those rules, because by that time, we should be fairly clear about what they are. Otherwise, it makes it very hard for people to submit on. If we do that, it's a practical way that still provides the protection. It takes it away from us needing to police things. It takes it away from, make sure that those areas are included in whatever stock take that the country needs to say that, yes, we're looking after our land down the south, even though those in the north haven't looked after theirs. And these rules have been imposed on us because they haven't looked after theirs. Political statement. But yeah, it's trying to make sure we're being as practical as we can and not creating more work for ourselves and more cost for our ratepayers than we already need.
Sorry, councillor Blackley, you wanted to. Councillor Hopkins.
Yeah, noting Mr. Cook's concern, I would also perhaps note the direction of travel of Parliament in Wellington at the moment, but I would also suggest that if the concern that we might be ultra vires had traction, then Mr. Crow's acknowledgement that officers have already left Q&A covenanted areas out because they are QE2 covenanted would be ultra vires too. So my view is you've done it. You've said in some cases this is a QE2 covenanted piece of land, ergo it doesn't need to go in our schedule. My resolution is very specific. It only says if there is an identified area here that happens also to have a QE2 covenant over it, and that in itself is most unlikely, I suspect, and that covenant offers equivalent protection, then essentially it adds to the list of ones you leave out. Essentially, we left some out. If there are any others that meet that criteria, which is very specific and precise, as advocated by the Mayor, I can't see a problem.
Mr. Campbell, you want to respond?
Thank you. I think we're sort of getting tied up in unnecessary sort of consideration of other factors. It's clear in the NPSIB that if an area meets the criteria, it will be mapped and included. And that's an exercise we can do with the Regional Council to assist as well. Going forward, that will pick up any areas with QE2 or any other protections or classifications. At the moment, our list is done for the areas that didn't have QE2 because landowners were happy to have them surveyed and was with their agreement. So it wasn't much points going to survey a QE2 area when we knew what the values were of it, or a dock area, that type of thing. Going forward, all areas will be picked up under the NPSIB regardless of their ownership or other covenants or protections. So unless the NPSIB is changed, councils will still be on that path of doing that work. What we've got now only reflects a point in history, what we did do, knowing that the QE2 areas and other protections were already identified and mapped. These list in the schedule pick up those areas that weren't, so we've got a better understanding of the values there. But going forward, all those areas would be picked up.
Thank you for that explanation. We do have a motion moved and seconded on the table. I'm required to put that motion to members of the subcommittee. So all those in favour of the motion, please say aye. Aye. Against? Carried. Moving along. Councillor Hopkins.
Yeah, Mr. Chair, look, I have, and I raised this matter earlier, and I would like officers to consider this. There are one or two properties, and I note on pages 589 through 593, and then there's also 626 to 637, 653 to 661. I'm picking out some of the more substantial ones, 616 to 620. there are in one case, there's Stoneburn, for the sake of argument, there's 11 pages. In fact, more than that, because you've got 626 to 637, and then 661 to 665 of SNAs. And I would probably, rather than try and relitigate all of them, I would probably ask officers to particularly give attention to pages 589 to 593, 594 to 596, 596 to 599, 604 to 606, 616 to 620, 621 to 624, 626 to 637, 642 to 645, 653 to 661, that's Baghdad, and 661 to 665, that's Stoneburn as well. I'd just ask you to look at those and perhaps try and wind them back, because they do seem to be an astonishingly significant imposition on particular property owners.
I've actually made a note, because of course, the property that you mention's in the Waihemo ward, so I do have a little knowledge, and yeah, there are 31 SNAs on that one property. But do you want to comment, Mr. Crowe, or?
Yeah, thank you, Mr. Chair. Happy to comment on that. So it appears that most of the sites that Councillor Hopkins has alluded to are those sites where, for example, you had several sites enumerated. You know, one of 15, two of 15, etc. This is partly because of the way that the surveys were undertaken. We had the district was split in two parts. We had two consultants, and both had a slightly different method of enumerating their sites. The most simple way to bring together those two data sets was to make every individual geometry, every patch, if you like, on the map, a separate SNA site. So some of those areas, particularly in the Waihemo ward, where you have ephemeral wetlands, a single site might only be a wetland that's a matter of meters across. It might be a very small site. Conversely, it might be several hundred hectares of grassland. So the number of sites doesn't necessarily reflect how large those areas are or what the values are in there.
Because I'd like to come back to what Mr. Campbell had said earlier on about the engagement of landowners. Now, my understanding in talking to the landowners of this particular property is, yes, that they opened their gates in 2018 and participated in the process. And so the first 22 SNAs were all part of that process. The last 9 SNAs, they are saying that they did not see the report until it was finished. They weren't consulted along the way, and therefore that they're feeling that it's just a total imposition because there's been no consultation. Having had a proven record of consultation on the first lot, and obviously meeting some compromises, I don't know the particulars. I'm more concerned about the process, not the particulars. So they're saying we've not been consulted. We've just been told there's the report. If you don't like it, get someone else to do a report that challenges it. Do you want to respond to that, or? I know we can't litigate every case, so if we can keep it to the general concept of how we're dealing with landowners, I think would be more productive than being specific.
On that last one, I think it was in relation to a consent to modify the land. So it was under a different scenario in terms of they need information to help inform that consent, and the information was provided. So it was under a different process than the previous survey for their site. So it's not really comparable in that sense, but as a result of it, them and other landowners that have asked for that as part of it have been given a report and they are welcome to work through it on the basis of the areas or the criteria, that sort of thing. But yeah, it was part of a different process to obtain that one.
Thank you. Councillor Hopkins?
Yeah, if I may ask Mr. Crowe a question, give me I don't want to say, I don't want you to think it is confrontational, because it isn't. But you mentioned ephemeral wetlands, right? Now, I've actually had a particular experience of those with a resource consent application at Macrae's Mine, where a planner for the ORC recommended decline on the basis of an ephemeral wetland that was, quite honestly, the size of the area in the middle of the state, in the middle of a paddock, was a slightly shallow depression with thistles and at least one sheep skull, I should say, in the depression. It seemed to me that its future as an ephemeral wetland was lost and gone. And if, for the sake of argument, I do wonder, Max, whether we are actually being a little pragmatic with some of these ephemeral wetlands and like it or not, taking the view that they're a lost cause, because I do think in some instances they are. And I think in that instance, that's an example. If we have it hasn't the horse bolted, if I may use an equine metaphor.
Through the chair, the sites, the criteria that the sites are assessed under includes consideration of whether or not the values have any ability to be retained under the existing land use. So that is something that is considered as part of the assessment. The viability of the populations is considered.
See, that wasn't confrontational at all. Thank you, Max.
But I do thank staff for their patience. I know some of these questions probably you swallow and go, but they are questions that are being asked in the public arena, and we have a responsibility to air them here so that we get an understanding of what's going on. So thank you for the explanations. Right, we're happy to move on. Is there any further?
Mr. Chair, I've got a whole list of things here where my notice was, has the owner consented or do we know? My view is, rather than repeat, go through the process of asking that question about every instance, I think we have to accept that in some cases, if there is dissatisfaction or unhappiness on the part of a landowner, they have, there is a possibility of parliamentary change, but equally, there is an absolute and guaranteed right to submit on the matter and have the submission heard by people who are willing to consider it with an open mind.
You know, thank you, Councillor Hopkins. Unfortunately, this debate has become emotional, and understandably so. I had a call from a ratepayer who was questioning a SASM overlay on his property. He reached out to iwi to get an explanation to try and find where or what he could protect. The overlay was on the basis that historically they harvested wood pigeons on his property. So probably similar to my own property where they historically harvested eels out of the river. A lot of the emotion and angst has driven concerns around this, and I wonder whether we couldn't have had a better mechanism where these things could be recorded as sites that historically have done that, but actually didn't need an overlay that potentially down the track will involve another or increase the steps in a process for landowners to carry out their normal lawful duties. It's a rhetorical question in passing. I don't seek an explanation, but I do want to acknowledge that we do understand the concerns that people have across the whole raft of these issues. And Councillor Hopkins is very correct that when we move to a proposed plan, the process becomes very clear as to the rights that people have to question what is being proposed. Mayor Kircher?
Just speaking in support of that, I think, Okaha on behalf of the Seven Runanga have put forward a lot of the areas which are detailed in the Ngāi Tahu cultural mapping, and that's commendable. But I think a lot of them are, it's not that there's anything necessarily there or that particularly needs protection. It's just part of this was where we did whatever activity and so forth, as Councillor Thompson said. And certainly speaking to one of Moraki's leaders, they were very relaxed about what we should or shouldn't include, to the extent where it was, he expressed that it's more trouble than it's worth for a lot of it. So it is trying to identify the things that we need to, and make sure that we're living up to what our partnership role in that. But it's a bit like trying to have another schedule where some of those things can be identified. They don't require, if something's going to happen on them, they don't require a resource consent, because as has been said in some of the meetings with that Runanga have helped front, that there haven't been declines on resource consents. They've a lot of them have gone through without any problem at all. Again, it's just creating more work than we need, and I'm sure more work than Okaha needs, to have areas identified that are subject to resource consents, but actually will never be a cause for declining a resource consent or even needing conditions on there. So I do, in the idea of principles, if we can eliminate areas or put them in a separate schedule where they're acknowledged but they don't require resource consent, any of those areas of Waihi Tupuna, that would be the better result, I think, for us. It would be a better result for the landowners, I'm sure. Well, I won't speak on behalf of Mana Whenua, but it's definitely something worth checking in with them. What areas could those could be identified that fit those criteria? Because it just would take a lot of the angst away that people feel, particularly when that is the place that they hunted their wood pigeon, or where they went across there as part of trails to the centre of the South Island, etc. So I'm not sure whether there's a motion in there somewhere, but I'm sure Jim will pick up on it if there is. But it certainly requires a bit more work, and I would prefer that happens before we publish, or before council adopts the proposed plan to be published. Thank you.
Yeah, that would be the question, Mr. Campbell. Is there a possibility of discussing with Okaha a two-tier approach to this?
Yes, we can certainly approach them and Meraki to see if there is a way of maybe splitting it, or identifying areas that are more important that resource consent is required, that have an interest, versus those that are more consult with but maybe not a consenting matter. So I know there's been a lot of discussion, particularly when we've gone through the provisions, in terms of what are the thresholds, particularly for land modification near cliff edges, that type of thing. So they have tried to kind of narrow it down to as much as possible, but whether there's another threshold that changes that or not, we can check with them. Yeah.
Thank you. Mr. Cook?
Just on that matter then, at the previous meeting, did the district plan subcommittee not approve the sites of significance to Murray? So does that now need to be revisited, that motion?
Mr. Chair, I've given that matter some thought. Mr. Cook's right. I did have one question relating to the chapter itself. But it did occur to me that that these matters could also be addressed when we consider the mapping. I would have thought that the critical matter here is where the rules might apply, and that will be determined by the boundaries and perimeters of areas identified. So Mr. Cook raises a valid point. In respect of the content of the chapter, I think we can ask officers for additional information or to report on particular matters. But as to the extent of anything, i.e. an ONL or an SASM, then I think that it is within our purview and our entitlement to propose amendments to the mapping.
No. Mr. Campbell?
I guess the opportunity is between any resolutions or recommendations made by this committee and the time when a report would go to council for the adoption of the plan to include any supplementary information from Ōkaha or iwi that says, here's an amendment to these maps or provisions. So that would be the mechanism to change. I don't think we need to change previous resolutions. It's to say, in light of any further discussion, here's a plan B that would come in and alter the proposed plan and alter that resolution accordingly. And then council would decide if they accept it or not.
I personally find that totally acceptable. The fact that the chapter was approved doesn't preclude the opportunities to further polish the document before it goes to council. Sorry? Yes. All right, so there's no further questions around the SNAs at this stage. All right, the silence is welcome. We can move on then. So the Schedule 8 as published, is this is the one that we're going to deal with, not the next one that needs corrected, is that right? Yeah, thank you, Mr. Campbell. All right, Councillor Hopkins.
Well, Mr. Chair, I don't know whether you want us done now or when the maps are discussed. I think it can be done either way, and in my view, well, perfectly happy to accept a ruling from you on that matter. But would you accept a resolution amending, if not the schedule of outstanding natural landscapes, then at least the mapping now, or do you want to do that later?
Well, I believe that the process requires us probably to deal with specifics rather than try and change the mechanism. But have you any comments on that, Mr. Campbell?
Because it depends what the resolution is.
Yeah.
Do you want me to?
Well,
why don't I put it and you can decide whether it lies on the table or it can be debated now?
Well, Councillor Hopkins, when I was reading the schedule, I thought it was describing you when it said memorability, naturalness, vividness, coherence and transience.
Thank you, dear boy. I'm all of the above. Here's my resolution. Officers may wish to cover their ears. I'm moving that all cultivated land and land containing any other elements and features required for agricultural industrial use is removed from the outstanding natural landscapes overlay in the draft district plan and that the boundaries of the ONL overlays are amended accordingly. And the second resolution is that all identified.
Sorry, can we just get that first one?
Do that again. If you just speak slightly slower.
That all cultivated land and land containing any other elements and features required for agricultural industrial use is removed from the outstanding natural landscapes overlay in the draft district plan, and that the boundaries of the ONL overlays are amended accordingly. And we need a second, don't we?
With councillor Percival, it's,
Can I want to put on record, I don't want to debate it at the moment, well, we will, obviously.
Percival has seconded the motion, yes.
I foreshadow that I have a second resolution, a second motion, I should say, yes. Do you want that now?
No, I
Okay.
think we'll,
Well, I just want to make this point that I can show my colleagues on either side handwritten notes on the 18 December 2023 subcommittee meeting agenda showing an initial version of that resolution. And I just want to make it absolutely publicly clear that this is me looking at a planning matter and circulating to members of the committee detailed planning arguments, which I think are sustained by other information we've received today, including evidence in reference to case law showing that there needs to be general regard to economic well-being when considering the sustainable use of land and resources. That's case law, and it hasn't happened. It didn't happen. Our landscape architects told us expressly that they didn't take economic considerations into account in assessing outstanding natural landscapes. I have challenged the legal, the standing and status of and authority of the Schedule 6 criteria on page 666 of our agenda. And in my view, the simplest and cleanest and most effective solution to the intense debate that's gone on is to do as I have proposed. And I'll just reiterate again, this is not a knee-jerk response to public criticism that I don't think has taken proper account of the process that's undertaken so far and will still be undertaken. I intended to do this on the 18th of December last year. We just ran out of time.
no, thank you, councillor Hopkins, and I will acknowledge that we did have emails interchanged at that time on this subject. Councillor Blackler?
I was wondering if councillor Hopkins would be open to a slight amendment of wording. Could you read me your sentence with the where it says cultivated?
Oh, they're all sorry, they're all cultivated land and land containing any other elements and features required for agricultural industrial use is removed.
So I'm just wondering, just to avoid any doubt, where it says agricultural industrial, I wondered if we could insert modified for partial agricultural or industrial, because not all agricultural practice is taking place on cultivated land.
Well, so let me be clear then. So that would read any other elements and features required for modified
For partial agricultural or industrial.
Modified for
Pastoral agricultural use or industrial.
yeah, okay. Yeah, I'm happy with that. Are you happy, guy?
Is there any further comment around the table? I'll let them all go and then we'll come back, David. So,
Chair, just speaking, look, I don't want to go, I've circulated, and I think the planners have seen this, and I think Roger's seen it. I did initially circulate a quite substantial email outlining arguments, I want to make it clear that I have not just said we don't like it, ergo it's not going to, it shouldn't be there. I've drawn on planning arguments and I've had some reliance on the purpose clause of the RMA, which has also been cited in other contexts in the course of consideration of this plan. And I have tried to validate the decision by using arguments that would at least be contestable in an environment court or if considered by an exterior agency. Equally, I've acknowledged that these are arguments only, they haven't been tested, and that any contrary arguments would need to be considered by anyone hearing submissions on the proposed district plan absolutely with an open mind. So this is not a matter of predetermination. It's simply a matter of actually trying to resolve an issue in a way that I think does so. And the second resolution, if this first one is passed, I think will reaffirm that or affirm that.
Thank you. Mayor Kircher.
Thank you very much. I was hoping that wasn't as right a reply and everyone else had lost their opportunity, but no, I support the intent behind this of fine tuning and being seen to be pragmatic about how overlays are applied. I understand the architect principles, perhaps of having larger areas, but yeah, we're dealing with the real world. We need to make sure that our productive sector is able to produce. So definitely support it. Unfortunately, I've got to actually shoot away for a meeting in Waimate with Waiho Runanga, so I'll talk to them about SASMs when I'm there. But I am very supportive of this direction generally. So thank you very much, Councillor Hopkins, for putting forward.
All right, well, if there's no further speakers, I'll put the motion. Oh, sorry, David, you'll write a reply.
Not so much right a reply, but just I guess some advice and where we need to go with it if it's carried. So the first thing is the outstanding natural landscapes and two features criteria has been developed over a long period in case law. And there is a New Zealand landscape assessment guideline, so that's all been followed, and our landscape architects acknowledge that some areas of ONL will be modified and cultivated. That's set out in case law. Most of Queenstown Lakes District is an ONL and it's heavily modified. So it could be problematic in that sense, just flagging that that's a known issue with a lot of landscape classification. The provisions that we've already recommended to council allow for quite a wide range of farming activities to continue, whether it's cultivated or not. And the provisions there to require consent where there's substantial change that might affect the landscape, but it doesn't mean that that change can't happen. So it's trying to get that balance, which we've already worked through. The other thing we've done, which isn't that obvious on the maps, but has been worked through quite carefully with landowners where they have vast majority of their property in ONL, is providing for farm base areas around their buildings and curtilage, and that would be taken out of the ONL. So that's identified for a lot of those properties in the Upper Waitaki, it's an Ahuriri area, and that was all with agreement with the landscape architect and the landowner, and they were happy with that, and it even included a couple of future areas that aren't even built on yet, that they signalled they would like to have a farm base or some farm infrastructure there. The landscape architect visited that site and was happy to exclude that from the ONL because of various factors. So that has already been worked through and has come through in the maps we've got. There's an item later today that has also showed where there's been some change and consideration of an area that was modified near Marama, and that has also been recommended to be excluded from ONL. The Canterbury, particularly in the Waitaki, the Canterbury RPS clearly identifies the ONL areas and excludes large chunks in the valley floors or irrigated areas, and we've left those as rural scenic. They don't have the ONL classification. So the implications are if the resolution is passed, we would have to go away and understand where the further areas within the ONL that are cultivated are, and then get landscape advice as to do they stack up or not as being excluded. Some of them might be just small paddocks up the Ahuriri or Oka valleys that are in a very big, significant landscape context. Others might be on the fringes of rural scenic, such as around Quailburn or heading up towards Twizel. So we'd have to look at those carefully and say, well, it's justified as ONL now. Does the existence of a area of cultivated land mean it's not so important as a landscape part of that land? So that's advice we'd have to bring back to the committee so you could have assurance that it's still stacked up under the landscape criteria. So that will take some time depending on where the areas are we map as cultivated. But just to give you the picture, we have done a lot of that work already for a vast chunk of it. But yeah, the extent of it may not actually be that big when you narrow it down to what's left cultivated in the ONL. A lot of it already is rural scenic and not ONL.
You might recall that at the previous meeting, Mr. Crowe showed us the map of the whole district and the bits of biodiversity that we needed to focus on. Those at the time, to me, what it showed was how much of the district is actually, modified and has been modified over time. And I would think that if I turned and headed up the Waitaki Valley over the last 150 years, I would have seen land clearance, land alteration for flood irrigation, the removal of those with the arrival of centre pivots, etc. That there's substantial modification over 150 years.
A point of historical order, probably about 700 years, if you include Polynesian settlement and land modification, modification of the land for their uses and purposes.
Unfortunately, Councillor Hopkins, I was just trying to keep it within your time frame of your lifespan. But the thing is, we need to acknowledge that things have been greatly modified, and whilst I have no qualifications as a landscape architect, I've spent considerable time reading these papers, looking out my lounge room window at the landscape, and I'm fortunate to have a lovely vista, but it is substantially modified. And I struggle to conceive of it as outstanding in the sense of needing some sort of protection, because it has been there for so long and will be going forward. Councillor Hopkins?
So same, Mr. Chair, if no one else wishes to speak, I wouldn't mind exercising a brief right of reply, and then we perhaps vote on the matter.
A very brief right of reply.
Well, look, I make a couple of points. In my view, if we make this change, if the subcommittee recommends this change, planners can come back to the full council with a detailed analysis or a counter proposition. It doesn't lock in place the change at the moment. My view also is the landscape architects have had relatively free and untrammeled and unchallenged reign for the best part of a decade or more. And in my view, if they want to actually challenge whatever we put in the proposed plan, they can do it like everybody else by way of submission. You know, if the landowner has to actually put in a submission and incur the cost of a planning consultant, let the landscape architect do the same thing. I would also make the point that there are at least two assertions on, and I've gone into this in planning in detail. I would challenge the assertion on page 666, where it says at the very bottom of the page, if a natural landscape or feature has at least one value in a very high range, it is categorised as outstanding and protected under Section 6 of the RMA. That is not correct. There is no such specific and explicit protection in Section 6. Equally, if you look at the very last of the criteria, shared and recognised assessments, the degree to which popular and expert opinions agree about the values of an area in folklore, art, poetry, song, history, or national or local identity. Well, in this case, there is clearly and definitely no agreement between, or very little agreement between popular and expert opinion. And the assessment tool does not say which you prioritise. Ergo, I argue that we're absolutely entitled to put as much or more weight on popular opinion as we are on expert. So I would suggest that the resolution be put.
Thank you, councillor Hopkins. As seconder of the motion, councillor Percival, you wish to speak?
Jim brought up a point which has always been a concern to me through this whole procedure, and that is the fact that the major influence that the contractors or the consultants have had on this whole process, particularly in the last 4 or 5 years, at a very costly enterprise for the council. But it's always intrigued me why this subcommittee has never requested that some of these consultants, particularly the landscape architects and the ecologists and a few others who've been, and I've actually been in the field with them, that they weren't here to actually answer the questions that we have, rather than the staff who are only working on their recommendations. And that, I think, is a vital part of this whole subcommittee's activities that has not been addressed. And is a huge concern, because now we're actually getting through some good stuff now, but there's a long way to go. But I do believe that those who are affected, this so incredibly serious matter they have, and affecting matter for our economy and our farming community, have not been called to hear to answer.
Thank you, councillor. All right, there being no further debate, I will put the motion to the members of the subcommittee. Those in favour, please say aye.
Aye.
Those against? Carried.
Mr. Chair, with your permission, I'll move a second motion. And I hope this may allay some concerns from our staff and others.
Can we have it slowly delivered, please?
That all identified individual outstanding natural features remain identified and mapped, including where they exist outside the new boundaries of the outstanding natural landscapes overlay.
I'll just get Mr Campbell to respond to that, councillor, because this is the one that we're referring back to, isn't it?
Yes, that's correct. So the features aren't in today's agenda, they'll be on the 18th of March.
Or can that lie on the table then? I mean,
Yes.
and it might be help. May I speak to this?
Yes, yes.
Based on what you've just said, what I'm trying to do is say, I know the landscape architects identified features, and clearly we don't want to see those just trashed, and that's not the purpose of the resolution number 1. So I would imagine that they would be identified in the same way that SNAs are, and that's what I wanted to achieve by that second resolution. But if you'd prefer to leave it on the table and have officers speak to it on the 18th, I'm happy for that to happen.
Can you just read that first bit again? Because I was just trying to get another row in my.
That all identified individual outstanding natural features remain identified and mapped, comma, including where they exist outside the new boundaries of the outstanding natural landscapes overlay.
I think what we'll do is what we've done previously. Councillor Hopkins, it's there and we will return to it on the 18th.
Thank you.
Are we scheduled for a morning tea break?
Yes, we are.
All right, I think this is an opportune time, members, to take a brief 10 minutes to load up on caffeine and a water biscuit because we are under austere times. And I happily invite ratepayers who are in the chamber with us to join us for a coffee if they want to. And staff as well, of course, goes without saying. And for those of you online, we'll be back in approximately 15 minutes. Colleagues, if I can, yes, no, I knew we weren't live. I was just. All right, welcome back, everyone. We have another 20 minutes of this session before we adjourn and reconvene this afternoon. So moving on through the ONL chapter. Are there any other issues the members of the subcommittee wish to raise?
Mr. Chair, I'll raise it, I will raise this, I rather suspect I know the answer the planners are going to give us.
Well, why ask the question?
Well, because I think it's important to actually register a challenge to some of the, I mean, we've got through from 666 through to I think it's 683. We have a series of enhanced descriptions of why things might meet an outstanding natural landscape criteria. And as I said before, I think that the landscape architects have to some extent co-opted a whole lot of stuff that's outside their remit. And I would just draw the committee's attention, subcommittee's attention to page 676. At the very top of that page, it says natural science. And this is an assessment of one of the lakes. As a man-made feature, the lake cannot be said to exhibit very high natural values, and also because of wilding infestations originating from hydro-era amenity plantings on shorelands and islands. However, the water quality, birds and fish wildlife are of high value. Now, the difficulty I have with this is a fundamental failure in New Zealand planning law. The only landscapes they value are rural ones. There's almost no account given to urban landscapes. And one of the things that I did actually circulate to the committee members was a short video I took. I don't know if it's able to be screened now, maybe this afternoon, but it shows an appalling urban industrial site in the foreground of what is one of the country's most significant natural landscapes, i.e. the volcanic craters of Banks Peninsula. And there appears to have been no restrictions imposed on the people who turned this industrial landscape into a visual wasteland. And it does trouble me that out in the country, even a man-made feature like a lake that can't be said to exhibit very high natural features and has wilding infestation resulting from hydro-era amenity plantings still gets called an outstanding natural landscape. And I mean, at some point we have to say to the planners or the planning industry, guys, have the same rules for everyone, or start to actually label things, brand things appropriately, because I don't believe an man-made lake it can be many things. It can be treasured, it can be loved, it can be hugely valuable, but it can't be a natural landscape.
Councillor Percival.
Yeah, just as a footnote to what Jim's just spelled out, under aesthetic naturalness, the highly qualified people who wrote this said, although man-made, the lake appears highly natural in its rugged setting.
So we take on board there is a reasonable level of scepticism around the criteria, but I would presume, Mr. Campbell, that it is industry best practice.
Yeah, it is. I mean, as you read it, it can come across that those criteria are obviously part of the mix of all of the values. So of course, a man-made lake or natural versus a natural lake are going to be rated differently because of that. But whether it's Lake Ohau, Lake Benmore, they still exhibit the same kind of qualities. That's what they're saying, regardless of how they're formed. And even Lake Ohau is modified to an extent with the siphon and control on it there. So that's the key difference. But what they're saying is, yeah, you read one and it sort of almost sounds opposite to the other, but these are just the different types of values they have to work through. Yes, we agree that Lake Benmore is man-made, and because of that, it's not the same sort of values as maybe Lake Ohau or Lake Middleton, but it still has the same qualities of a lake in that environment. So, but that's just how they record it, really.
I think what Mr. Campbell has just said is that an ostrich is a horse.
No, I don't think so.
No, it's probably more a moa versus an ostrich, which is now extinct.
I must contend or commend participants for retaining a sense of humour in what can be a very dry subject. But there is a perplexing question which overarches the credibility of all this work the landscape architects have done. I would find it far easier to accept if it was a science rather than an art. So much of it appears to be a very subjective rather than objective process. So there's nothing as we surf through the pages raising the ire of members of the subcommittee.
Mr. Chair, I do have a question. If we can just go to page 716 of that original agenda, and this is Schedule 9. Just a question. Could officers just clarify, this is listed as a schedule of significant natural features, and yet I'm pretty sure that elsewhere they're referred to as outstanding natural features. So could just a clarification of that, a very, very procedural matter. None of them appear to be numbered at this stage, so I presume that will be addressed. But the other question I have in regard to these features is what, if any, engagement with landowners has there been, and do we have any sort of documented indications of consent or agreement that these things are either ONFs or SNFs, whichever?
Mr. Campbell?
Yeah, so this is sort of moving out of the ONL schedule, but I'll just respond to the questions.
Thank you.
Anyway, but so there will be a schedule of outstanding natural features coming to the next meeting that was omitted from this once it was tidied up. The numbering will be fixed up in the schedule of significant natural features, so that's to come. And all of these were mapped and sent out in 2021 to the 1,300 odd landowners that had various features across their property. So there's been a lot of dialogue back and forth in terms of relooking at those. Some have disappeared as a result of that. So there's been quite a bit of change since the 2021 and even the 2022 draft. Yeah. But yeah, the ONFs, outstanding natural features, will come in the next meeting.
Sorry, through you, Mr. Chair, if I may. So our SNF, significant natural features, is that something in the RMA? So just refresh, I'm sorry, apologies if this is evidence of me not being diligent enough, but what provisions do we have in the draft or proposed district plan specifically relating to SNFs rather than ONFs. Everything I've seen so far relates to outstanding natural features. What are we saying? What provisions are there relative to SNFs, please?
Thank you, Katrina.
Thank you, through the chair. The natural features and landscapes chapter, in its entirety addresses, outstanding natural landscapes, outstanding natural features, significant natural features and rural scenic landscapes. There are some rules within the chapter that apply specifically to ONLs and ONFs. And there are some rules, there's a sort of more relaxed tier that apply to significant natural features and rural scenic landscapes. So there is more provision there to allow activities to occur in those areas than there are in the higher tier areas.
So supplementary again through you, Mr. Chair. It is reasonable then to conclude that SNFs are lower in the hierarchy and that the rules regime is more relaxed as it would be also with rural scenic. So if for the sake of argument, the ONL boundary modifications change, there would still be provisions that might protect an SNF or also would apply to an area that would be classified as a rural scenic zone.
Yes, that's correct. Yeah, thank you.
Thank you for those explanations. All right, well, if there's no further questions on the ONL chapter, as per previously, I would presume that that we can move the acceptance of the chapter with the changes as recommended. So I'll just ask members of the committee to consider that. In the meantime, Councillor McCone.
Yeah, I just have one question, clarification. So the description of the ONL and everything else, is there any consideration taken the financial consideration of reclassification of that land?
Not in terms of the assessment criteria, which is at the start of the chapter. It's only a identification mechanism, and then the Section 32 analysis around the provisions covers the cost benefit analysis of whether it needs consent or not, that type of thing. So that's an RMA consideration we have to document as well, but not of the actual classification. It's of the rules that we just talked about in terms of the hierarchy for outstanding rules a bit higher than the ones for rural scenic, for instance. So that's where we balance that out.
So who is responsible for the Section 32 if they disagree with the way it's been done?
Where?
Yeah, so we provide those Section 32 reports. They're all part of the notified plan. Yeah. And they can be challenged through submissions as well.
All right. All questions done and dusted. Do we have someone prepared to move the chapter with
Amendments as agreed?
Yes.
Yes, I'm happy to do that, Mr. Chair, with your permission.
Thank you, Councillor Hopkins. Madam Chair.
Let's just be clear about what we are moving, because at the moment, my next recommendation here is all about the schedules. So which chapter are we moving?
Sorry, it's, yeah, it relates to Schedule 8
Okay.
of ONL.
So correction then. I move that Schedule 8 be adopted with amendments as agreed.
Thank you, Councillor Hopkins. Seconded, Councillor Blackler. I'll put that to the members of the subcommittee. All those in favour, please say aye. Carried. And although we've got 2 minutes left, I think that's an appropriate time to adjourn the meeting, and we will resume at 1:30 this afternoon. Thank you for those watching and for those who have attended, and we'll be back with more riveting tales from the spectre of planning